Good morning. My name is Paul Craney with Massachusetts Fiscal Alliance. I appreciate everyone joining. We should be done in about half an hour. We're going to have some speakers today and then open up to question and answers. Massachusetts Fiscal Alliance advocates for fiscal responsibility, transparency, and accountability in state government and increased economic opportunity for the people of our Commonwealth. In this case, we're going to explain how different taxpayers and organizations are going to try to hold the state auditor accountable to Massachusetts general law. The speakers today will be CLT, Chip Ford from CLT, Dan Winslow from the New England Legal Foundation, and Jonathan Riches from Goldwater Institute, and then we'll open up some questions. Chip, if you're there, make sure you're unmuted and take it from there.
Yeah, I'm Chip Ford, Executive Director of Citizens for Limited Taxation. This is an interesting history to this issue. There's a dynamic tension between taxpayers and the tax imposers. And every time a tax is imposed that taxpayers feel is abusive, they generally wait about 11 years before they finally go to the ballot. This was the case with the income tax, temporary income tax increase that was imposed in 1989. We went to the ballot in 2000, and the voters agreed with us to roll it back to 5%. But it took 32 years from the time it was imposed until the time it reached 5% finally. It's the same situation here with the tax cap. Then Governor Dukakis in 1975 imposed a income surtax. 11 years later, right on time, CLT went to the ballot and proposed a surtax repeal and a tax cap going forward. It passed on the 1986 ballot. It was implemented once in 1987. Here we are, 3 decades later, it's being implemented for the second time. Every time taxpayers do take a tax issue to the ballot, there's a generational lapse between the tax and the tax being returned to where it was. And this is another one of those cases. Here we are, the tax cap has been implemented. It is on the books. 36 years later, it's been triggered, and now it's time for the tax rebate. We understand there's another organization also filing their 10 out of 24 taxpayer lawsuit or preparing it. The difference is ours is comprised of the original supporters, the original organizations who went to the ballot in 1986, put it on the ballot, ran the campaign, and won the surtax repeal and the tax cap. And that's Citizens for Limited Taxation, my organization, and the Mass High Tech Council, which is also a plaintiff in this case. So if there's any questions that anybody wants to ask, I'll try to answer them.
Thank you, Chip. We'll get to questions at the end, so just keep your powder dry. I do want to go to Dan Winslow and then Jon Riches.
Yeah, thank you, Paul, and thank you all for joining us today. I'm Dan Winslow. I'm the president of the New England Legal Foundation, which is a public interest law firm based in Boston with a focus on free enterprise, preserving the rule of law, and protecting property rights. The taxpayers have lawyered up. The law has been on the book, 62F. It has a provision to allow its enforcement through the Supreme Judicial Court. Our hope, of course, is that the public officials involved will carry out their oath of office and follow the law as it's written, which, if they do, results in a sizable tax credit back to the taxpayers, which they voted for and which they deserve. But if that doesn't happen, we're prepared to go forward with a lawsuit to compel compliance with the law as the law provides. Now, there's been some talk about the legislature coming back into session and repealing this law, and just want to pose the question that there's a very real risk that this credit has already vested. That is, that this could already be a vested property right in the hands of the taxpayers to which they're entitled. And so that question needs to be seriously considered if there's any thought about undoing this law. And if the law's on the books, it should be followed. And we're prepared here at the New England Legal Foundation, working together with our colleagues at the Goldwater Institute, to stand up for the taxpayers and make sure that the law is followed and that there's respect for the rule of law. Thank you, Paul.
Thanks, Dan. Jonathan Riches from the Goldwater Institute.
Thanks to Dan and to Paul and to Chip. I'm grateful to be part of this alliance. The Goldwater Institute is a public policy organization and a public interest law firm. We have a long history of protecting the taxpayer, whether that's unlawful tax increases, whether it's unlawful government subsidies, and this falls directly within that area. I mean, look, it's a sad reality that oftentimes elected leaders refuse to protect the taxpayers. And in this case, taxpayers took it on themselves to impose their own protections to ensure that those taxpayers' will is protected. We're going to take any measures that are necessary to ensure that Chapter 62F is enforced as it was drafted, as it was intended to be enforced. We trust that the public officials involved will comply with the law's plain and express terms. In this case, the auditor has two very simple functions: to review for completeness and accuracy the commissioner's original estimates, and then to determine the level of the tax exceedance for purposes of the tax refund to taxpayers. We are here, along with New England Legal Foundation, to ensure that the plain language of that statute is honored and that Massachusetts taxpayers are protected.
Great, thank you, John. So if it's not incredibly obvious to you, in your inbox, you should have a letter that was sent to the auditor's office this morning. We have prepared more than 24 plaintiffs. The plaintiffs come from every county of Massachusetts. They are serving as taxpayers, not as their organizations. However, many of these plaintiffs are affiliated with organizations that many people know. They include taxpayers from CLT, Mass Fiscal Alliance, the Fiscal Alliance Foundation, Chris Carlozzi from NFIB, Chris Anderson from the Mass High Tech Council, several people associated with Beacon Hill Institute, Mike Hubry from New Jobs for Massachusetts, taxpayers from Citizens for Fiscal Responsibility Belmont. And like I said, about a month from now, September 21st is the day that we would file suit. So we wanted to have this press conference about a month out if the auditor does not comply with the law that she's required to on September 20th. So with that said, I want to open up to any questions. Just a reminder, unmute yourself if you have a question. If you can, just state your name, who you're from. And I will just say Mass Fiscal Alliance over the years have done a lot of things for the people of Massachusetts. 2 years ago, we helped kind of lead the effort to stop ranked choice voting. About a year ago, we led the effort to stop the TCI gas tax, and these were all very significant benefits for the people of Massachusetts. But this could arguably be the biggest benefit for the people of Massachusetts. Close to $3 billion going back to about 4.7 million taxpayers. Anyone that pays an income tax will receive a refund. So we're really happy and honored to be part of this. And I just want to recognize the important work that Chip Ford did in 1986 with the late Barbara Anderson and Chris Anderson over at Mass High Tech Council. We couldn't be here today if it wasn't for them. So I want to open up to questions. If you have any, feel free to ask.
Hey, Paul, it's Allison Kuznets from Mass Live. Can you and other people on the call just talk about how likely do you think it is that Auditor Bump and other state officials will not comply with 62F?
Dan, do you want to take that one?
No, we're aware that the auditor is receiving significant political pressure to delay the certification with the thought that the legislature would repeal the statute when they come back into session at the top of the new session. And there's even talk about possibly having the legislature come into session now to repeal the law as part of another package. And that's why I raised the question about whether or not this right is already vested. Basically, what remains at this point is what we call a ministerial act. It's simply almost an automatic kind of a certification because the close of the fiscal year was June 30th. And so the condition that this statute applies to already existed, as a matter of fact. So we think that if if the law is not complied with, it's a layup in terms of enforcing the law. But if there's delay in an effort to try to impede the effectiveness of the law, I think there's also a significant risk to the Commonwealth that they may be paying the taxpayers twice if in fact that's not their wish.
Hi, guys. This is Ben Kale with Boston Business Journal. I'm curious if there's been precedent for this type of thing in other states that you guys are aware of that you can speak to.
Yeah, Paul, this is Dan. This initiative in Massachusetts by CLT and the Mass High Tech Council back in 1985-86 was unique to Massachusetts. I'm not aware of a similar statute that exists in the country, but I'll defer to Chip at CLT and as well to Goldwater, which has a national scope.
No, I'm not aware of another, but this was important back then. We had just passed Proposition 2.5 in 1980, which limited municipal taxes, and thought it was important to limit state revenue as well, and that's why we introduced the surtax repeal and the tax cap.
The specifics of this ballot proposition are unique to Massachusetts. Taxpayers have elsewhere put in place certain protections, both in terms of limitations on government spending and on taxes that must be or that can be collected. For example, we were involved very recently in a case in Arizona where taxpayers imposed a constitutional cap on spending for public education. Some out-of-state interests attempted to run a ballot initiative that exceeded that constitutional cap. We were forced to bring an enforcement action to the Arizona Supreme Court, which did in fact enforce the constitutional limits on that spending. So there are multiple instances in which taxpayers have themselves imposed various limits on spending and on taxation, but this one specifics is unique to Massachusetts.
Hi, this is Bruce Mole at Commonwealth magazine. You're all talking about 62F and tinkering with that, but the governor appears to be pretty willing to tinker with the way the money would go back. He wants to speed it up to this fall, and he wants to send it out, it sounds like, in the form of checks. Do you object to doing that rather than doing it on credits, which is what was written into the regulations originally as credits in next year's tax bill?
Bruce, this is Chip Ford. When this law was drafted back in 1985, 86, we had to be cautious not to appropriate funds, or it would have been found unconstitutional and never would have got on the ballot. So we used the term credit. We didn't use it in the accepted sense that it can only be returned as a tax credit in future years, though that was the way it was interpreted in 1987. Nonetheless, our use of credit was that the taxpayers would receive a refund.
And Bruce, this is Dan Winslow. The focus for the New England Legal Foundation is respect for the rule of law. If the law were to change to give money back directly rather than a credit for future taxes, as long as the law is being followed, that's our interest. But we do think there's a significant question whether this value, this monetary value of these credits already has vested. That is, whether this is already a property right to which the taxpayers are entitled, whether it comes in the form of a credit as written or perhaps tweaked to the form of a check remains to be seen. But there's a significant question that this actually may already be a done deal as a matter of law.
Yeah, and I would just add, obviously, the legislature failed to act on any type of tax relief, and people are really suffering right now with inflation. So if the governor wants to expedite the process, on behalf of taxpayers, I think it'll be well received. I don't think that's a problem whatsoever. So $3 billion back into the state economy, or whatever exactly the number is, I think is a very good thing. It should be done as soon as possible.
Let me follow up, if I could, then, just for another question. How, if the governor wanted to send out a check in late November to taxpayers, so the original regulations for this sort of calculated how much, it's sort of a calculation based on what you owed in 2021, and then you take that credit on your 2022 taxes, would this be just the governor would be able to figure out what you owed on your 2021 taxes and just send that to you as an amount? Because it seems like I don't know, I get a little lost in the calculations if you don't do it, follow the rules as were originally set up. Anybody got any thoughts?
Bruce, I think that could be like a Department of Revenue question you might want to ask them. I'm sure they've thought about this extensively.
Okay, but bottom line, you guys don't care how it's returned as long as the total amount is returned in some fashion. In some fashion to taxpayers, I guess.
We care that the law on the books is followed, Bruce. If the law is amended by the legislature to change the form of the payment, that's the law. But that's the question that I'd raised earlier, which is this value already may have vested in the hands of the taxpayers anyhow. So that there's an open question there. It may make sense not to tweak it at this point if that question is unresolved.
Bruce, this is Ben Robbins from NELF. Just to answer your question, whether it's the form of the tax credit, which was what was intended and expressly provided by the statute, or the governor's effort to expedite in the form of a refund, the amount at issue is already determined by the statute and the implementing regulations. So that amount initially, as Dan has already said, that I think has already vested. So that amount is already a sort of a certainty once it's hopefully duly certified by the state auditor. So whether, again, it's in the form of the credit for next year's tax filings under the scheme of the statute and the implementing regulations, or through some expedited effort by the governor in the form of an actual refund to taxpayers within this year, that shouldn't affect the value that is returned to each taxpayer. That's already been determined by the statute itself, if that makes sense.
It does make sense, but I think the law sets the total amount. What I'm talking about was what an individual taxpayer could get, because theoretically someone could have a liability from 2021 and apply and figure out the credit based on that, but not have a liability in 2022 and not take advantage of this. So how it pays out to individual taxpayers, you're talking about the big number, the 3 billion. I'm talking about how do you actually send it out to individual taxpayers? How much does each person get? And that comes down to how you write the regulations about how you do this. And that's what the governor is starting to tinker with, I think.
See, I thought that was based on your filings from that is 2022 filings for 2021. That determines how to apportion that lump sum excess. It's based on your 2021 filings that have already occurred. Now, whether that's, again, a credit for a future filing or simply a check returned to you within this fiscal year is the open question. But again, I think the implementing regulations follow up based on your filing from the past tax year. That is when you file in 2022 for tax year 2021.
Okay.
I think that's how it works.
And do you guys all support, I guess what I'm sort of curious about, why do you think the governor is eager to move this up? Is it because the legislature could come in next year and change the law, or attempt to change it, come even next year and try to change the law theoretically? Is that why he's trying to move it up?
I believe he's already stated that, and I agree with him. A bird in the hand is better than two in the bush. With this legislature, anything's possible, and they could drag this out forever. So I think that the sooner the taxpayers are fully reimbursed, the better.
Yeah, and keep in mind, remember, the legislature for about a year and a half has been talking about providing some kind of inflation relief through tax reform and tax rebates, and that never got over the finish line. So providing some immediate relief in the fall or early winter, I think will be well received for the taxpayers in Massachusetts.
I want to add one point on Dan's value word. In a situation involving 10% inflation, if a payment made promptly is not going to be degraded in value, but a payment that turns into a credit on the 2023 tax returns is not going to be due and payable until 2024, which is nearly 2 years from now. 10% inflation compounded 2 years. You can figure it out, guys. That's a great degradation in the amount the taxpayers will receive for something that has vested value.
Want to be mindful of everyone's time. Are there any other questions for media? Remember, unmute yourself if you do have a question. All right. Well, thank you for your time. This recording will be on the Mass Fiscal YouTube page a little bit later. Press release and a copy of the letter will be sent out momentarily. The auditor does have in her possession a copy of the letter that was already sent out. Any follow-up questions, feel free to reach out to me and I'll direct it to the appropriate person. And I appreciate everyone's time today. Thank you all.
Great. Thanks, everybody.
Thanks.
Take it out.
Thanks.